Okay, direct examination of the defendant concluded. Philip Dube, what do you think?
He's a very likable witness. He has a very tranquil demeanor. He's a success story. He's very relatable. The problem is there is no smooth segue or transition from having a good time to this sudden onset of aggression. But having said that, if the jury believes their story...
Yeah. Sorry, let's listen in.
Sure.
Okay. We're going to take a quick break. So pick up your thought, Philip. You know, a lot of people think the opposite. Our producer in the courtroom believes that the jury is not buying him, and at least before the text messages came in, especially some male jurors were mad dogging him, according to our producer in the courtroom. That may have changed after they heard the text messages. I don't know. But pick up where you left off. The issue with his story is the, you're saying the 0 to 100 scenario?
Yeah, I mean, they're having a lovely evening. They're at the cafe or this, bistro, having a lovely dinner and drinks. They go home. I guess they're going to pick up where they left off, go out and get more drinks. And then all of a sudden, you have this abrupt transition from a lovely evening to this conduct involving physical aggression. The segue is weird. You would have to believe that she's some type of psychopathic drunk, that all of a sudden, once the alcohol is absorbed in her system, she becomes a mad woman and gets physically aggressive. It's a very strange transition. On the other hand, on the stand, he doesn't lose his cool yet. He's very tranquil, very relatable. For purposes of proof beyond a reasonable doubt, if a jury believes them equally, it means he should be acquitted because the prosecution didn't meet their burden. If you believe them equally, 50-50, that's not proof beyond a reasonable doubt. So, we'll see what happens on cross.
Don't they also, if a jury is told two different stories and both are plausible and they need to go to the one that leads towards innocence?
Innocent, exactly. I mean, that's a standard jury instruction throughout this country. If the evidence is subject to two or more reasonable interpretations, one pointing to guilt and one pointing toward innocence, the jury is required to adopt the interpretation that points towards innocence and acquit the defendant. Because if you should only have one interpretation. If the prosecution wants to prove its case, there should only be one final conclusion, and that's guilt. But if you really don't know, it could go either way. It means you have a reasonable doubt, and that doubt goes to the defendant. The tie goes to the defendant.
The frustration we saw with the prosecutor while the jury was not in the room during the proffer can't happen in front of the jury, obviously. What are you looking for here? What do you expect on this cross? Do you keep it short, knowing you're likely going to have this rebuttal for the he said, she said conclusion, or do you keep him on there forever and try to stumble him, get him frustrated?
Well, I think what I would do is try to get him frustrated, because at some point she's going to put him in a posture where he's going to end up blaming his lawyer for everything. Why is it all of a sudden now or a year later we're getting all these screenshots? So you want this jury to believe that you waited all this time, you gave them to your lawyer, that your lawyer suddenly a year into it turns it over? Okay. And that's typical. We have these situations oftentimes where the client is sort of losing and then they throw their own lawyer under the bus. And a jury might not take kindly to it because now you're putting your lawyer in evidence. That actually puts you in conflict with your own lawyer. But hopefully this lawyer, he's a solid stand-up guy, will know how to rehabilitate him and ask the proper questions on redirect.
Basically the state has to, in its questioning of the witness here, confront him, right, and say, isn't it true you fabricated these text messages? Just be very clear and see his reaction, because, again, with their rebuttal witness, it's going to come down to who do you believe?
Of course. And then I would also parade the photos of her injuries, and just, show them to him and put them on the Elmo, the overhead, so the jury can see her all blown up on the overhead screen as he's talking about it. And when you look at the injuries, they didn't just come out of the firmament, they obviously happened somehow. And I don't know, it might be a reach to suggest that these are all self-inflicted. I mean, if you think about it, Ted, how would you cause that type of contusion to your forehead? Of all places, it's a weird place to have an injury. Most people, if they're going to, self-inflict a facial injury, it's going to be to the cheek, maybe to the chin, but to your forehead, as a practical matter, how would you even inflict it? Are you going to take an object and just slam it into your own head? It kind of doesn't make sense, and a jury might have a hard time believing that. Now, on the other hand, her injuries do not jive with what she said went down. The way she characterized that whole course of conduct, the way he was dragging her around by her hair, almost like a caveman, you would think she would be far more injured than how she presents in the photos. So a jury might think that maybe she was cuckoo and, as we say in the public defender world, cray-cray, and just fabricated this whole thing to take him down.
Well,
we don't know. We'll have to wait and see.
He just said under oath that she ran into the door, that the door was open, and they were going from 0 to 60. He comes back with the dog. She sees him on the phone and freaks out, and then runs and boom, hits her head on the door. This is a fascinating case. It's the ultimate he said, she said.
It's a very plausible explanation. Listen, at the end of the day, when somebody has injury, the prosecution still has to prove causation. If there was a willful infliction of some type of traumatic injury like this, there still has to be a causal connection between the defendant and the injury. And if there was some supervening cause where she trips over her feet down the stairs or she runs into a door, you don't blame the defendant for that. There's just like this causal break in that chain of causation that cannot redound to his detriment. Let's assume, that's really how it happened. It's not necessarily self-inflicted. It all occurred accidentally during an argument. And to blame him for her own injuries where she just lost her footing or took a bad step or plowed into a door, it's not his fault.
The bottom line is one of these two individuals is lying through their teeth, and they did it under oath in front of this jury. If a juror if you have jurors that think, you know what, I don't trust that guy. I think he's lying. But now in closing, the defense gets up and says, here's the law. If these are two viable stories, you have to go this way. Is that what we should expect from the defense? And isn't it kind of advantage defense when you have two competing stories that make sense?
Oh, of course. I hammer that instruction all the time in criminal cases, especially when you have a he said, she said situation. And by the way, Ted, in criminal trials, you know what my favorite number is? 1. The number 1. You know why? Because we only need one juror to hold up this entire verdict. You don't necessarily have to convince 12. The law does not require that all jurors reach a unanimous verdict. They can each stand their ground. There's also a jury instruction where they are required and told that their verdict must be their own. It's not a majority rule situation where you throw in the towel during deliberations just to get out of there and go home and call it a day. You have to give your meaningful input. You have to deliberate meaningfully. Otherwise, you end up convicting innocent people. And if you have one or two who want to hold out, then so be it. Let's retry this.
How about the question that we all had before this proffer of, well, why didn't someone come in here from a phone company, and you already talked about, and basically legitimize these texts? How do you get that across to the jury now on cross-examination? Because right now, jurors are thinking that. They're thinking, wow, these texts are real, this changes everything, but the state has to get out that they think not only that these texts are made up by you, Mr. Liar Defendant, but how do you then tell the jury, we tried to do it, but AT&T didn't help us with this? We couldn't verify them. Is that in closing?
It is, but you have to be careful because remember, a foundation was already laid for the introduction of these texts outside the presence of the jury, where the court found that they were properly authenticated and a foundation was laid. There has to be some evidence then in response to that showing that they were fabricated, that they were altered, that they were just in fact, made up. If you don't have that evidence,
Yeah.
I don't even think you should be allowed to argue it.
Philip Dube, thank you for your expert opinion. Pins and needles, we have cross-examination of the defendant coming up next. We'll slip in a break here.